Good evening, ladies and gentlemen, and welcome to the 8th. It's hard to believe it's the 8th night of our series, our bi-weekly series. We are Constitutional Revival. I'm Royal Alexander, and I'm very happy to be with you here on our 8th night. I again want to thank Joanne Woodard and David Hagar for making this thing possible to even begin with, because all I do is sit here and talk, and they make the rest of it come together. David Hagar's company is Beyond Innovative Technologies and Consulting, and he does a great job for us. By the way, anyone wishing to review material that we have already been through, please go to the YouTube channel, Constitutional Revival with Royal Alexander. I think, according to what David told me, we get it up within about a week, if not sooner, of each episode of the class. So please go to YouTube to catch up on anything, and that will allow you to fill in any gaps if you haven't seen every one of the series. As you recall, last week I touched on the Fourth Amendment, and I'm going to do some more because these next three, let me frame it up like this. These next three are really aimed at our individual rights as it pertains to criminal matters. They're all constitutional matters, obviously, but tonight, this is more law enforcement oriented. This is more, what are my rights? What can they do and demand of me? What can they not do and demand of me? So, as my law professor used to say, there's no better place to begin than with the text. The Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, there is a lot in that paragraph. There's a lot in that extended sentence of about 70 words. There's a lot in there. I touched on several of these things last time, but this is what I want you to keep in your mind. The right of the people, so it's us Americans, to be secure in their persons, not just our physical body, but our houses, papers, and effects against unreasonable searches and seizures. It has to be unreasonable. Searches and seizures. And searches are different from seizures. There is entire lines of cases devoted to what a search is. There are entire lines of Supreme Court cases devoted to what a seizure is. So listen to the words. Unreasonable searches and seizures shall not be violated. It's a blanket prohibition. And no warrants. Warrants are very important. No warrant shall issue but upon probable cause. They got to have probable cause, which is greater than reasonable suspicion that a crime has just been committed. Supported by oath or affirmation. Law enforcement has to sign the warrant before a judge grants it, saying, Your Honor, I'm testifying that everything that's in this warrant is true to the best of my knowledge and belief. In other words, Judge, I haven't made anything up tonight, kind of like James Comey did to get that FISA warrant to go and investigate President Trump's campaign. They knew the Fusion document was a product of the Hillary Clinton campaign. He knew it, and several of the others at the very top of the Department of Justice knew it, but they didn't tell the FISA judge. They lied on the warrant. Well, that's why I hope they're prosecuted, because right here the Fourth Amendment says it's got to be supported by oath or affirmation, which means you can't lie or you're going to be in trouble if you're a law enforcement officer. You can't lie that you think Royal has cocaine over at his house, or that Royal's neighbor is growing weed or counterfeiting money. Can't lie about that. You got to have probable cause. That's where the oath or affirmation comes in of the law enforcement officer. Judge, I'm swearing that I believe this to be true. And particularly describing the place to be searched. They get those things wrong often. They're in a hurry. They think a crime's happening, or we're going to lose a criminal, or they're going to destroy evidence. This happens pop, 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 quickly. But you still have to particularly describe the place to be searched and the persons or things to be seized. You can't go on some fishing expedition just because you have a warrant. Your search is limited to what the warrant says. We think in the back bedroom, he has a counterfeiting machine. If the warrant just allows you to look in the back bedroom, you can only walk in the front door to my back bedroom. Now, if you see something as you're walking through, because you do have a lawful right to be here, to walk through my house and go to the back bedroom to see if there's a counterfeiting machine back there. You have a lawful right to do that. On your way, walking through my house, if you see a pile of cocaine on my table, that's the plain view doctrine. You don't have a warrant to arrest me for the cocaine, but because you have a right to be in my house, using your own eyes in plain view, you see some cocaine on my table, you can arrest me for the cocaine. Although by itself, you could not have been in my house without a warrant looking for cocaine. But only because you've got a warrant to be here to look and see if I have a counterfeiting machine, were you in my house in the first place and you saw the cocaine on my table. That's why this is important. Again, keep in mind what we're talking about here. And by the way, the Fourth Amendment just prohibits government violations, not personal violations. Personal violations are false arrest, they're, assaults, batteries, all of those are between citizens. I'm talking about, what we're talking about in the Fourth Amendment is a restraint, once again, on government, what government can do to you. So what did I tell you last time? What is the most important question to ask when determining whether or not a Fourth Amendment search and seizure were legal? Because if I don't remember to say it at the end, I want to say it now. If the police officers, if law enforcement doesn't do these things correctly, then I promise you, if I'm the criminal defense attorney at trial, I'm going to try to have any evidence they had. If that warrant that allows them to come in my house and go look and see if I have a counterfeiting machine, if there's anything illegal about them being here, about that warrant, about probable cause, then when they try to bring in evidence against me that they saw that cocaine on my table, I'm going to make a motion on behalf of my client to suppress that evidence of cocaine on my table, because I'm also doing it about the counterfeiting machine, by the way. But I'm trying to show you two different analyses. But I'm definitely doing it about the cocaine, because they weren't even supposed to be here in the house. I'm doing it about counterfeiting, but don't think you're all going to get me on the cocaine, because but for the counterfeiting warrant, which was flawed, I'm going to argue, you never would have seen the cocaine. That's what's called the fruit of the poisonous tree doctrine. If the tree is poisoned, so is all the fruit that comes from the tree. If the warrant, if the search, if the way they got the judge to sign it, if anything, probable cause, if anything is illegal, then the counterfeiting machine, the cocaine, everything is out. None of it gets to come in court because it's part of the fruit of the poisonous tree. The poisonous tree was the bad search, the illegal search of my house. And any fruit from it, counterfeiting machine, cocaine, or anything else, human trafficking out in the back house, just imagine I have a whole criminal enterprise going on. None of it can come in because they never had a legal right, a constitutional right to be in my home in the first place. I want you to understand that. Those are one of the 3 or 4 most important principles about the Fourth Amendment. Okay, so what is a reasonable expectation of privacy? And again, we talked about this last time, so I'm going to move through it a little more quickly. What is a reasonable expectation of privacy? My home is the place every American has their greatest expectation of privacy. A man's home is his castle. The common law calls the area right around my house the curtilage. You can't even penetrate the curtilage in common law. Of course, Louisiana is civil law. We have similar things. Sometimes I think I should be allowed to double bill because I know both the civil law and the criminal law. But of course, the Louisiana State Bar is watching. I'm just joking. I would never double bill. Anyway, that is kind of funny. But in the common law, it's called curtilage. In the civil law, it's simply the perimeter around your home. You can't penetrate that either because the curtilage was part of the O.J. Simpson trial way back in 1994. How far those officers could come toward O.J. Simpson's house to look for evidence. These issues, when people try to tell you the Constitution doesn't matter, they're just simply ignorant. And that's the most charitable word that I can use. They're ignorant. These things happen every day. The Fourth Amendment, the Constitution is relevant every day, every day. So what is a reasonable expectation of privacy? Keep in mind, a search, we have searches and seizures. People love to blow past the words. A search, keep this in mind. A search can mean everything from a frisking by a police officer on the side of the road or coming out of a movie to a blood test, to a search of an individual's home or their car. All that can be a search. Police officer doing a blood test, frisking you, searching an individual's home or their car. All of those are searches. Let's put searching aside for a minute. What is a seizure? A seizure concerns when the government takes control of an individual or something in his or her possession. A seizure is when the government takes control of me, and if I have a wallet or a gun or a phone on me, they seize that too. I have been seized, but there's a fine line. Keep in mind, when we do this course, I'm just giving you big principles. We could drill down for miles into this stuff, but I'm giving you big principles and concepts and ideas that I want you to keep in your mind so you know when you hear something, you do this analysis in your mind. First of all, was it even a search? Secondly, was it even a seizure? Was it a legal search or was it an illegal search? Was it a legal seizure or was it an illegal seizure? I want you to start doing this analysis. This is thinking like a lawyer, like we've talked about. Most warrantless searches of private property are prohibited by the Fourth Amendment. Warrantless searches, meaning you have to have a warrant. For instance, a warrantless search may be lawful if an officer, but these are times where you don't need a warrant. So by and large of your home, you have to have a warrant. That's why on the front doormat of my office, it says, go back and come back with a warrant. Leave and come back with a warrant. Even though that's my office, it's not my home, but still it's where I work. And they're not coming to get any of my clients in my office. I want them to see that right when they come in the door. Leave and come back with a warrant. Okay. But specific exceptions apply to the warrantless searches. If an officer asks and is given consent, this is a big one. Please remember, you do not have to give consent. I promise you that if they could just arrest you, they would have. There's some doubt in their mind about whether they can arrest you. So they're asking, please, can we just kind of come in and look around your house? Can we look around your car? And I'm not mocking anyone. I'm just saying, please think this through. You're an American citizen. You have constitutional rights, and you don't have to give consent to search your home, your car, your body, nothing. Because again, if they had the legal authority to arrest you, they wouldn't be asking. They wouldn't be asking. But don't feel intimidated at your front door saying, well, can we just come in and look around? And you immediately think, well, God, they're going to think I'm guilty if I don't let them. Please put that thought out of your mind. You don't have to let anybody in your home. Believe me, if they have a warrant, they're coming in anyway. So if they're asking for your consent, well, man, we're just trying to make some routine checks, trying to we're all on the same team here. No, you're not. We're not all on the same team. I'm not bashing them. Law enforcement is very important, but my clients in law enforcement are not on the same team. So when they come to the door or on the side of your car, ma'am, could you step outside? They can ask you a few things. I've told you, if you're drinking and they pulled you over for speeding, they now had a legal right to be in your space, and they can go further. Have you been drinking tonight, ma'am? Because they smell alcohol. That alcohol is essentially the plain view doctrine has become the plain smell doctrine, okay? Everything bills on everything. But if they never had a right to pull you over in the first place, like you weren't speeding, you didn't have a tail light out, you did signal when you changed lanes, or I call them ticky-tack traffic violations, but they're still law. They're still ordinances. We can't speed. You know, you got to signal, you got to come to a complete stop before you turn. That's ticky-tack, but it gives a police officer the right to get up in your space, pull you over. Oh, I noticed you just ran the red light. You're gonna be like, no, I came to a complete stop. No, you kind of came to a rolling stop, meaning, sir, you never completely stopped at the light. When during the middle of the day, people do that 1,000 times, but things are busy. Now we're at nighttime, there's far less traffic, and they know, again, it's not enough probable cause to see you pull out of a popular restaurant or bar. That doesn't give probable cause to pull you over. Going down the street away from the bar, you have to do something that creates a violation, usually of a traffic ordinance. You're having fun, your stereo's cranked, you're in your Corvette, the top's down, boom, you done it. But if you're going the speed limit, just the fact that you're in a very fast Corvette, going down line is not enough. You got to speed, you got to move over to the right lane without signaling. You got to not come to a complete stop. You had a tail light out. So they're looking, because they don't want to go to the work of all this. A lot of police officers are very fine, smart people. They're trying to do their job right. And they're not going to go through the trouble and effort and time of stopping you if they don't think they have a basis to do it. Because they know you're probably going to get a lawyer like me who's going to come and go through every one of these points, point by point by point, to see if they did it correctly. Because if they didn't, we're getting an acquittal. It's getting dismissed. Okay. What's a reasonable expectation of privacy? What's a search? What's a seizure? Now, exigent circumstances, and you probably know what the word exigent means. Hurried, pressing, pending, immediate, exigent. It's an emergency happening right now. The circumstances call for action right now. Exigent circumstances exist in a situation where people are in imminent danger, where evidence faces imminent destruction. Like if we don't get in there quickly, they're going to flush all that cocaine down the commode, or prior to a suspect's imminent escape. That knock and announce rule, you see it all the time on TV in these police shows. Knock and announce. Boom, boom, Chicago PD. Boom. Then they're going in. That's called knock and announce. Then they're rolling. Then they come with that big hammer. But they got to say they're there. Okay. Exigent circumstances are another grounds for not having to have a warrant, but you better have probable cause that drugs are being destroyed, that a suspect is escaping, maybe a murderer is running down the street or something. You better have probable cause, because if not, when you go arrest them, when you got to try to use those drugs, if you didn't have a right to be there, if there weren't truly exigent circumstances, the evidence is getting thrown out of court. And it's going to be hard to get a conviction on my client. So these things all go together. But most of the time, particularly I'm talking about in a home, you have to have a warrant. Okay. On the other hand, I've already talked on searches and seizures of property that are legal if the objects being searched are in plain view. Here's another one. If I'm a police officer and I'm in a parking lot and I walk by and I see what looks like weed or cocaine up on your dashboard, plain view gives me probable cause to get into your vehicle, possibly arrest you, but to see if that's plain view. Plain view. Okay, there's so many things now. As I touched on last time, just pulling someone over is not enough. Then you can only search within the area for the officer's safety where the suspect, where the individual could reach for a gun. You know, depending on if it's a woman with a shorter arm, that's the space. If it's a man with a longer arm, that's the space. You can search in those areas, But that doesn't mean you get to look under the front seat or in the console or in the trunk. So again, under the Fourth Amendment, each step has to be watched carefully. This is so fact intensive. Every arrest is so fact intensive because what seems like exactly the same in this stop may be slightly different over here, making this arrest illegal and that arrest legal. Okay. And I don't have time to go into every single thing, but what is the expectation of privacy? The greatest is in your home. Probably the next greatest is in your yard. Of course, you're out in the public in your yard. Certainly your car, your vehicle, is another place where you have a great amount of privacy. Not nearly as much as in your home, but certainly greater than walking down the street. You do have a lot of privacy in your vehicle. Keep in mind about plain view. Warrantless searches of abandoned property or of properties on an open field don't violate the Fourth Amendment because they're abandoned or because they're on an open field. Now, keep in mind, I've said this before, states cannot give less protection than the U.S. Constitution, but states can give greater protection. So right there, some states will say, oh no, you're fine without a warrant to go search in plain view of an abandoned property or an open field. Some states said, yeah, police officer, go ahead and search without a warrant. Other states said, no, even in open fields or abandoned properties, you're getting a warrant. That's giving greater protection than the Supreme Court has given based on the U.S. Constitution. And a state can give greater protection. It just cannot give less protection. All right. Keep in mind that we have plain view doctrine, we have plain smell doctrine. If we're never getting into this, I just want you to know that when a law enforcement officer deprives any of us of one of our constitutional rights, whether it's under the Fourth Amendment, whether it's under the 14th Amendment, whether it's under the First Amendment, there's lots of different ways to infringe, to violate our constitutional rights. They can be sued in the Fourth Amendment directly based on the Fourth Amendment itself and what's called a Bivens action. Bivens was a particular case that the U.S. Supreme Court said, we're going to allow a suit to be filed against federal law enforcement officials for damages resulting from an unlawful search and seizure. That's directly from the Fourth Amendment. But we also have something called 42 U.S.C. Section 1983, and I've had several of these cases in federal court. If there's a constitutional deprivation by someone acting under color of law, that's not just Joe walking down the street. Under color of law means what it sounds like. It's got to be a police officer, got to be an FBI agent, got to be CIA, got to be a state trooper, got to be a sheriff's deputy. That's color of state law. When a person who is in law enforcement acting with the authority of the law, or as we say, under color of law, violates your rights, they can be sued. Now, how that's done is a whole different area of constitutional law. I just want you to know it happens. Okay. Now, there are cases in the Fourth Amendment area that move one tweak, one click over, or the two cases would have been the same. You're like, I read that case yesterday. That's exactly the same as today's cases. No, it's not. I promise you, it wouldn't be in your criminal law school handbook, textbook, if there were not a difference. It may be just a little, but that little nick, little difference makes all the difference. Okay, in one case, and this is a famous one, it's called Arizona v. Hicks, U.S. Supreme Court 1987 case. The court held, think about this, that no seizure occurred when a police officer called to the scene of a shooting incident, wrote down serial numbers of stereo equipment that he observed in plain view. So he went racing over because somebody called in, oh, shots fired, shots fired. The police officer goes rushing in. So that the shots being fired are what gave him probable cause to be there. While he's there, he notices in plain view, he writes down serial numbers on stereo equipment that he thinks, I'm sure, probably was stolen. Well, that alone was legal. Right to that point, the officer was fine. He had a right to be there because of the shooting. When he got there in plain view, he saw some speakers. He's thinking, I bet those are stolen. They're in plain view. I see the serial numbers. Okay, no, I don't want to go that far. There are the stereos. Let me tell you what the problem was. And this kind of distinction is all throughout Fourth Amendment law. What did the officer do? He's over where he can be. He sees the stereo. At that moment, he's still fine. But listen to what he did. He thought they were stolen. Nevertheless, the officer's actions, because he went over and he moved the stereo equipment so he could look at the back and write down the serial number. By moving the stereo equipment so he could see the serial number on the back, the serial number, right, or VIN number, whatever it was, he actually did an illegal search because he didn't have a warrant to look behind the stereo equipment. In plain view was just the front of the stereo equipment. He could take a picture of it and send it. Say, can y'all get me a warrant really quickly? But where he lost, because right up to then, the shooting got him there legally. He's looking, I'm in a place I can be. Now I see, wait a minute, there's stereo equipment. He walks over to it. He's thinking about it. I bet that's stolen. Right then, he's fine. He could have snapped it on his phone. Of course, 1987, they didn't really have that capability, but theoretically. But what got the search knocked out? He went and leaned the speaker down back and looked at the serial number, and that was considered an illegal search. He didn't have a right to go rummaging through the stereo equipment just because he thought it might be stolen. All he had to do was a right to be there. All he had was a right to be there because of the shooting, to then notice, oh, that stereo equipment sitting right over there in my plain view. Today, he would snap pictures and say, give me a warrant for this, give me a warrant. And if they could, he could come back. Then he could look behind it. But that's a fascinating case. You see how tiny the distinction is. Right up until he looked behind the stereo equipment, he was fine. But that's how it's so fact intensive. It's so fact intensive. I mean, so many, yeah, well, there's hundreds of thousands of arrest cases. But one little twist can distinguish something. One little different fact, you know. So that's what I want you to keep in mind. And one other thing, we talked about the fruit of the poisonous tree doctrine, and all it says, again, it's called the exclusionary rule. The exclusionary rule is similar to the fruit of the poisonous tree doctrine. It's almost the same principle. What the exclusionary rule means for purposes of evidence is that any evidence obtained in violation of the Fourth Amendment will be excluded from the trial. Meaning, if the officer didn't have a warrant, if he or she didn't have probable cause, if they did more than just plain view or plain smell, if they didn't have a right to pull you over in the first place, if the search, if the original stop and search were illegal, and they don't have to be both, you can have a search. If any of this was illegal to begin with, anything you learn by being there illegally, if you never had a right to be in a house in the first place, any drugs, illegal guns, human trafficking, counterfeiting, anything you learn while you were there is getting suppressed. It's not coming in as evidence in trial because the search was illegal. Okay, that is the Fourth Amendment to the extent we are going to tear it apart. But please keep in mind that you don't have to consent. It's all about what a reasonable expectation of privacy is. The greatest expectation of privacy we have is in our homes. It begins to go down, but you still have a significant expectation of privacy in your car. But just don't give law enforcement a reason to pull you over. And they'll do ticky-tack. And I'm not bashing anyone. As I say, most of our law enforcement officers do a great job. But look, they're out there working. They just saw you pull out from a very popular restaurant and you gunned it. Boom. You gunned it up the street. They're going to try to say, you know, if you're not reckless and you stay in your own lane, if you go from 0 to 45 miles an hour really quickly, that's not illegal. you got to be sure and stop at 45. Don't swerve. But if you just gun it in your lane and go from 0 to the speed limit 45 really quickly, that alone is not illegal. But don't swerve lanes without signaling. Don't fail to come to a complete stop. Don't have a taillight out. Don't let them be legally in your space, because once they're in your space, they get to say, could you step out of the car? Oh, I smell the odor of alcohol. Have you been drinking? Each step lets you go further in your search. Okay, please keep that in mind. Now we're going to do the Fifth Amendment. The Fifth Amendment is also a major criminal defense right that we have as American citizens. It is the rights we have to defend ourselves. It was painstakingly, of course, every amendment, the whole Constitution was painstakingly wrought, but so was the Fifth Amendment. Once again, my law professor would say, no better place to start than the text itself. Here's the Fifth Amendment. And as before in the Fourth Amendment, every word means something. We're going to tear it apart, but let's do it, the whole thing now. No person shall be held to answer for a capital or otherwise infamous crime, which means a serious crime, unless on a presentment or indictment of a grand jury, except in cases arising from the military. They have the Uniform Code of Military Justice. They have their own code. So everything outside of the military and people in the military. No person shall be held to answer for a capital or serious offense unless on presentment or indictment of a grand jury, nor shall anyone be subject for the same offense to be twice put into jeopardy of life or limb. I know you know that's double jeopardy. Nor shall be compelled any individual in any criminal case to be a witness against themselves, against himself or herself, nor be deprived of life, liberty, or property without due process of law, nor, and I sometimes think the framers just needed, this was a hugely important principle, this last one, but it's not really like the rest of it. I've thought for years they needed a place to put it in, so they said, we're putting it in here. Nor shall private property be taken for public use without just compensation. And I could be totally wrong. I'm sure James Madison knew exactly what he was doing. But the first large part, balance of the first part of the Fifth Amendment is about these criminal rights we have. And then, but one more time, let's do it again. No person shall be held to answer for a capital crime unless on presentment of an indictment, presentment or an indictment, they're similar, of a grand jury. We're going to talk about grand juries in a minute. Nor shall a person be subject for the same offense be twice put in jeopardy of life or limb, double jeopardy. Can't do it. You can only be tried once. Nor be deprived of life, liberty, or property without due process of law. That's in the 14th Amendment too. And we're going to talk about that later. The difference between Fifth Amendment due process and 14th Amendment due process. But right now, in the Fifth, you also, no person can be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. Okay. The Fifth Amendment requirement that a serious, and again, these are federal crimes. In other areas, I've told you, the Supreme Court has incorporated a particular amendment to the states through the 14th Amendment. That has not happened here. That has not happened relative to the Fifth Amendment. So I'm talking about, these are federal criminal charges, not state charges. States don't have to do it this way. A lot of states do have grand juries, but they don't have to. Anyway, the Fifth Amendment requirement that serious federal criminal charges be started by a grand jury, which is a group of citizens. It comes from the English law. Again, that's the common law that the other 49 states practice. But of course, we in Louisiana are wonderful and different, and we do it differently, although it's still pretty similar. But this is a common law principle, a group of citizens who hear evidence from a prosecutor about potential crimes. That's a grand jury. It's rooted in the English common law, and its basic purpose is to provide a fair method for beginning criminal proceedings against those accused of committing crimes. Again, they can be issued, grand jury charges can be issued against, you know, in the news when they say, the reporter comes on and says, we have breaking news. A grand jury indictment has issued against Jerry Jones, the owner of the Dallas Cowboys. A grand jury indictment has issued. Well, that just means a prosecutor, if it's a state law in Texas, that just means state law would allow for grand juries. Unless it's a federal criminal law, then a U.S. attorney. A U.S. attorney could bring, who knows what Jerry Jones might be arrested for. No offense to Mr. Jones, but that's what a grand jury indictment has issued. All it is a prosecutor sitting in a room without an individual's attorney. Without an individual's attorney. That's what's so unusual about the grand jury process. Okay. To avoid giving government unchecked powers, grand jurors, regular people, are selected from the general population, and their work, conducted in secret, is not hampered by rigid rules about the type of evidence that can be heard. Well, if you do criminal defense, those rigid rules are the very things that protect your client. So grand juries scare criminal defense lawyers because they don't get to be in the room with their client. It's just the client sitting in front of this group of people, the grand jury, being asked questions by a prosecutor. And the joke is always, my God, any prosecutor worth his or her salt could indict a ham sandwich. They're so good. The grand jury is so willing to be led around by the prosecutor that the prosecutor could indict a ham sandwich. That's always the joke. But in fact, grand jurors can act on their own knowledge. They can go further than the prosecutor, and they're free to start criminal proceedings on any information that they think is relevant. So we intend for our grand jury process to mean something, and it does. But keep in mind that the whole point is when they're selected from the general population, they aren't hampered by rigid rules. Like they can just ask anything. And that's scary because, you know, if they could misspeak and all that's being written down. So what they say may lead to their indictment or the indictment of someone else, like your client. So grand juries are fascinating things. A significant number of states don't use grand juries, by the way. Instead, they begin criminal proceedings using what's called a bill of information or the indictment, the presentment. It just says in clear language, Royal Alexander is being charged with unlawful transportation of Schedule 4 narcotics across state lines, if we're in federal court. Or if we're in state court, something very similar. I'm being charged with distributing, possession with intent to distribute of methamphetamine, whatever. It's got to be spelled out under the legal statute, the law, which makes it illegal, in clear terms. That's part of my rights, to know exactly what charge or charges is being brought against me. And if it's not clear, then the criminal defense attorney can file essentially what's a vagueness motion, forcing the prosecutor, telling the judge, Your Honor, it's not clear in what the prosecutor has done here. The charges in this indictment are not clear. So we don't know what my client's being charged with. We're filed a motion for you, Judge, to order the prosecutor to refile an indictment in much clearer terms and more detail and better language, so we understand what my client's being charged with. But keep in mind, the grand jury, it's for federal criminal charges. Some states use it, but they don't have to because it hadn't been applied to the states through the 14th Amendment yet. But again, a lot of states do use grand juries. And next time you hear the breathless, today so-and-so and so-and-so had a grand jury indictment issued today against Cowboys owner Jerry Jones for da-da-da-da-da. More news at 10. That's because it's a serious deal. Because a group of people sat in a room and either asked questions of Jerry Jones himself or people right around him and thought that they learned enough to issue an indictment. An indictment is merely that. And I'm glad. Please keep this in mind. An indictment is merely the bringing of the charge. It is a long way from proving someone guilty beyond a reasonable doubt. An indictment simply says, we've managed to indict the ham sandwich today. Not really. Because a lot of grand juries do listen. They're thinking, okay, in my experience, that sounds weird, strange. Why did you go do that? Why did you do that? I think there's evidence here that he maybe committed this crime. So I'm going to say there's sufficient evidence here to issue an indictment. But the indictment is really just the first step on the long road to proving someone guilty beyond a reasonable doubt. So don't let the fact that an indictment issued, just like when someone gets sued, it sounds dramatic. Well, it doesn't really anymore because people get sued so much in our country. But all it is, it proves nothing. It simply means either I, the prosecutor, or you, the plaintiff, think you have sufficient evidence to either sue me, say I rear-ended your car in a car accident if we're in civil court, or if you're a prosecutor, you think I was selling drugs. And so you're going to question about that. And now this group of average people, the grand jury, thinks there's enough evidence to say, Royal, I think you were selling drugs. So we're going to allow the prosecutor to essentially issue the indictment. We're the ones finding the grounds for the indictment, the grand jury. Okay, that's grand jury protections. It's a very interesting way of doing it. That process, the grand jury process. Okay, still in the Fifth Amendment. Let's talk about double jeopardy. I know a lot of you know what this is. It's important. Once a trial starts and what they call prejudice has attached, even at the beginning of a trial, there's a point beyond which, even if it's the very start of the trial, the very first few minutes or first hour of a trial, once essentially prejudice or jeopardy attaches, then that person can never be tried again for that thing. And there's again, like so many things, the attorneys will argue, the prosecutor will say, Your Honor, prejudice hasn't attached. Jeopardy has not attached. We can still try the defendant again because you declared a mistrial and said we can't go forward. And if I'm the defense attorney, I'm saying, oh no, Your Honor, oh no, jeopardy attached. My client cannot be tried again for this. Double jeopardy. All it means is it protects the individuals from being twice put in jeopardy of life or limb, that is, in danger of being punished more than one time for the same criminal act. That's so important that we only be punished one time. And they better make the case very strongly then to get to proof beyond a reasonable doubt, which is a long way on the spectrum of evidence to reach. I've said before, in my mind, in a civil case, I rear-ended you in my car. You were stopped at a light, I rear-ended you. All that's necessary there for you to prove your case against me is that a simple preponderance of the evidence, basically 51-49. The majority of the evidence supports your position that I rear-ended you, injured your back, and you had to get a back surgery. That's a preponderance of the evidence. And a preponderance, as I say, is about 51-49. Proof beyond a reasonable doubt is much further. The framers wanted, they didn't demand absolute certainty of a accused guilt, of the defendant's guilt, but they got pretty close to it. Proof beyond a reasonable doubt. You can't even have a reasonable doubt. You got to be certain this didn't happen, either did happen or didn't happen beyond a reasonable doubt. In other words, you can't have any doubt that this happened. You sitting there saying, he may not have done it, but I kind of think he did do it. That's not enough. you got to say, I've seen a bunch of evidence, and I'm virtually completely certain he committed this crime. That's proof beyond a reasonable doubt. And again, on the proof spectrum, on the spectrum of proof, it's much further down there than just a preponderance of the evidence if you and I have a car accident. Anyway, I didn't want you to write. Now, double jeopardy is very important, but I think it's a concept that you understand. But again, keep in mind, why is double jeopardy important? Because really the government, the city, the state, the federal government, the CIA, the FBI, they have all the government resources. They have all the forensic experts, investigators. They have all the time. They have the best DNA. They have the best forensics. And if they're going to come take a swing, they better connect the one time, because they don't get two swings. It's not 3 strikes and you're out. When they step up to the plate in a trial, they better get it right. Because once jeopardy attaches, once if there's a chance an individual could be argued to be being tried a second time for the same offense, that's double jeopardy and it gets knocked out. You can't do it. So the government has enormous power, and the double jeopardy clause is rooted in the idea that the government should not have unlimited power to prosecute and punish criminal suspects. It shouldn't. Rather, the government gets only one chance to make its case. But look again, it has so many resources, prosecutors. It's got multiple prosecutors, and if it's a serious enough case, a DA or a U.S. attorney can start pulling assistant DAs or assistant U.S. attorneys into the case. They got great investigators. They got great forensic machinery, great forensic equipment. So they get one swing at the apple. They better connect with the ball, and it pretty much better be a home run if we're going to get to proof beyond a reasonable doubt. So keep those things in mind. Now, what about the right against self-incrimination? Everybody knows I plead the fifth. I plead the fifth. That is a powerful right that we have. It's also a derivative of there's a presumption of innocence. Just because someone is arrested, we tend to think, oh, they must have done something bad. But in the eyes of the law, they have not. Let me tell you, I have clients that I'm representing who were arrested 2 years ago for whatever, DWI, maybe a little bit of drug possession, maybe a little bit of allegedly, all of these things, of course, allegedly, maybe a little bit of domestic abuse, a few other things, maybe some fraud, allegedly, and allegedly. Well, their case hasn't come to trial. So in the eyes of the law, they are still completely innocent, even though they were arrested 2 years ago, and me and the assistant district attorney, the prosecutor, keep bumping the court date or bumping the trial date all that time. My client is still presumed innocent, and if they made bail, they're out and they're free as a bird. I mean, that's still hanging over them, but I've had clients tell me, you know, Mr. Alexander, when we get these extensions of the court dates, I just feel like I'm a free man. And I never have the heart to tell them, well, you certainly are free till we get a new court date, but you're not really free. But I never say that because I want people to be happy and because I believe that I'm going to get them acquitted. So they are free for that period of time. Anyway, but the right to remain silent is part of the right against self-incrimination. I take the fifth. Some of the most dramatic in movies, when they jerk these big corporation owners who've pilfered the pension funds, like Bernie Madoff and others, who've stolen from their companies and their employees' pensions. They know, and they don't want to be, and they're in court or they're being any sort of hearing. I plead the fifth because I have a right not to incriminate myself. I have a right not to say anything right now on the grounds that what I might say might tend to incriminate me. So you have a right to remain silent, and anything you say can and will be used against you. So you don't have to talk. You don't have to talk. I always tell people, just be polite. If you've been pulled over, just be polite. Officer, I'm not going to participate in any of the tests. I would just like to speak to my attorney. Oh, you're not going to take the breathalyzer? No, sir. You're not going to do the walk and turn test? No, sir. You're not going to do the horizontal gaze nystagmus? No, sir. Well, we're going to take you downtown. You're going to be arrested. That's fine, because you're going to be arrested for about 8 to 10 minutes. You're going to get down to the station. You'll be booked. They'll do the picture, whatever. And then if I'm your attorney, you're going to be bailed out quickly. And then in 60 or 90 days, when I get your case and you haven't taken the breathalyzer and you haven't done the horizontal gaze nystagmus test to see what your eyes are doing, they love to look at your eyes. Then they love to put that flashlight right in your eyes, which many times I get cases dismissed over because the human eye is very fragile. It's sensitive. They're absolutely not supposed to put that flashlight to blind you in your eye. They're supposed to do it lower. Aim it low enough to see your eyes, but not blind you. If they put it in your eyes, I'm going to move to get it dismissed, because you can have a legitimate horizontal gaze nystagmus if your eyes are blinded. The walk and turn. Don't do the walk and turn, because you may stumble. You may stumble because you're tired. You're exhausted. Some people work 3 and 4 days in a row to make ends meet. Then they go crash. That doesn't mean you're drunk. So don't do the walk and turn test, because you may not be able to do the walk and turn. Your eyes may be so exhausted. And by the way, there's other reasons people have glassy, bloodshot eyes, by the way. A lot of people have allergies. A lot of people get colds. I've asked on cross-examination, I've asked police officers, in all these years that you've been driving, officer, have you ever swerved in the road? Have you ever sped? Have you ever moved from one lane to another without signaling? Like we all haven't done that 10,000 times. Of course, he's going to have to say, well, yeah. Okay, do you drink and drive? Oh, no, I don't drink and drive. Well, but you swerve. You just said you swerve. So if you don't drink and drive and you swerved, or you were speeding, there must be reasons other than swerving or speeding. There must be reasons other than drunkenness to cause someone to swerve or speed. There's no way they can go anywhere but say yes. Okay, so my client has allergies. Did you know my client has allergies? Do you know my client has been taking medication for some sort of pituitary problem or a diabetes problem? There's all kind of medicines. That's why you always get asked, are you on any medication today, which might cause you to be impaired in any way? All of this, you don't have to participate. I can't believe how fast this hour goes. It's 6:52. I feel like we just started. You don't have to participate in any of those tests. None of them. Just be polite, because you're going to be on video. Officer, here's my license. My proof of insurance is in the car, or here it is in my wallet or whatever. I'm going to give it to you. I'm not going to participate in any tests. And then they're going to say, well, we're going to take you downtown. That's fine. We're going downtown. Because I promise you, if you do any of those things and you even make a tiny little bit of a mistake. First of all, if you take that breathalyzer, if they smell alcohol on you and you take that breathalyzer, because I want you to know, first of all, there are other things that smell like alcohol that are not alcohol. That's one thing. Two, just because you may have had a sip of a beer does not mean you meet the legal standard for drunkenness. So they may smell it. That means nothing. That means nothing. Okay? Don't participate. Be very polite. Officer, I'm not going to participate in any test. Well, I smell marijuana. Officer, I understand, but here's my driver's license and my proof of insurance, and I have nothing to say. I would like to speak to my attorney. That's when it's getting shut down. Please put your hands behind your back. You're getting handcuffed into the car. Quick ride down to the police station. Out, uncuffed, print, picture, boom, bailed out. But in 60 or 90 days, when I get your case, they're going to have nothing to use against you other than the officer saying, I smelled the scent of alcohol. And I'm going to say that plenty of other things can smell like alcohol. I'm going to say that plenty of other things besides drunkenness cause glassy, bloodshot eyes. So I just give you these examples to know you don't have to participate. This is all part of your right against self-incrimination. So don't feel intimidated at your front door. If they say, can we just come in and could you just consent to let us search your house? We kind of don't have a warrant, but could we just come and search? No. Because if they had a warrant, if they had what they needed, They wouldn't be asking. They wouldn't be asking on the side of the road. Do you mind if we look in your trunk? If they had grounds to go look in your trunk, they wouldn't be asking you for permission. I promise you. But you don't have to consent. You don't. And all I'm telling you again, we desperately need law enforcement. We desperately need to be grateful to them at every level. The large majority of them do a great job. The large majority of them know what these rules are, and they don't want to waste their time on a bad arrest. They don't, because in 6 months, they don't want to think, I spent 3 hours that night and the attorney just got this kicked out because I screwed up on something. They don't want that. They want it to line up and they want to try to do it right. But you don't have to help them convict you. You don't have to help them convict you. That's what the Fifth Amendment, that's what our whole Constitution is all about. You have powerful individual constitutional rights. And this one is against self-incrimination. The other one, including the right to remain silent, including not testifying against yourself, not saying a word, including not testifying at all in trial. And you're deciding as the defendant who's being accused not to testify at trial cannot be used against you. That's another thing. You sitting over there, you and your attorney deciding, you know, I know I can testify and I think the jury will believe me. Your attorney may say, that prosecutor is very good on cross-examination and I'm worried you might get trapped on the witness stand. I'm worried he might trip you up. So you don't have to testify. And the prosecutor can never say anything. That's grounds for a mistrial. If the prosecutor ever hinted, you know, if Mr. Alexander were so confident that he's innocent, why didn't he testify? Brother, if that ever comes out or any form of it, I'm getting a mistrial very quickly. You cannot use the fact that the defendant did not testify on the witness stand or any other way against the defendant, like as proof of their guilt. Cannot do it. That's the quickest way to say, Judge, I move for a mistrial. Moving for a mistrial. The prosecutor knows he's out of control. He knows full well he can't do that. Boom, mistrial. 3 minutes left. I know I always, but these, you know, when I go over things, it's because I want you to know them, like in your head tonight going forward. The only other thing, we didn't talk about takings. Okay. The taking, you have the right to due process. We've already talked about due process. All of these things, the right to not be deprived of life, liberty, or property. It's here in the Fifth Amendment, just like it's in the 14th Amendment. We've talked about that. So I'm not going to spend time on the right to due process. We absolutely have the right to due process, and it includes all these things I'm talking about. But very quickly, to finish the Fifth Amendment, the takings clause, very quickly. You know what the takings clause is. If the city of Shreveport or the city of Baton Rouge, or I see Memphis has joined us tonight. Memphis, thank you for being here. The city of Memphis. If anyone, the city, I don't know, Memphis, if y'all have a city council or what your city form of government is, but let's assume you have a city council, or maybe y'all go by a police jury, whatever. Let's say your police jury wants to, well, what they're doing is appropriating your private property because we think we can make that a hospital. We think we could use your land to make a school, that we desperately need a school, or maybe a road, a public road. It's got to be for a public use. It has to be for a public use before the power of eminent domain. Eminent domain. I'm going to go on 2 more minutes to finish takings, or maybe 3. The power of eminent domain. You've heard of it all your life. The government can essentially, it's like seizing, but I don't want to confuse it with the Fourth Amendment. They're seizing it all right, but the word is appropriating. Under the takings clause of the Fifth Amendment, all it says is that, again, you've got to be paid what's considered the fair market value. That you have to be, if the government is going to seize your land, a private person's land, it has to be for a public use, like a hospital, school, road, something like that. Now, the point, you already know that. You know of eminent domain. I know you've heard of that. No, I'm not going to say seizing. It's the appropriation, the taking of, often, almost always, because that's what implicates the eminent domain power, a private person's property. Okay, Royal, I think your house could be far better used for a hospital. So we're going to take your house from you. A court is going to require us to pay you the fair market value of your house. So whatever I paid for my house, they're going to come take it. They're going to have to pay me something within, that's what they call just compensation. What are the value of houses like mine in this area? I have no idea what it is. Say 300,000 or something. Then they would have to pay me $300,000 if they're going to come take my house and my property and turn it into a hospital. Okay, that's constitutional law. But I want to tell you what the Supreme Court did in 2005 in a case that made a lot of people mad. And it surprised me. But this case was called Kelo, K-E-L-O, versus the city of New London, Connecticut. Kelo versus the city of New London, Connecticut. Keep in mind, the reason what I'm about to tell you matters is because typically we're talking about the City Council of Memphis, the City Council of Shreveport, City Council of New Orleans. Who else is on here tonight? Let's see, Atlanta. It looks like Atlanta's on here. City Council of Atlanta. The city government coming in, taking your property as an individual. They got to pay you fair market value. That's usually how that's assessed. But they're taking it for a public use. The government is taking a private person's property for a public use. Again, the government, the city council is taking a private person's property, me, right over here at my house on Erie Street, for a public use, like a school, like a hospital, like a road. That's going to benefit the whole public. That's the typical use of the eminent domain power. The reason this Kelo case was so different and fired people up, if there's one thing that's valued in this country, it's the Second Amendment, it's our freedom of speech, and it is our property rights, our sacred right to property ownership in this country. Well, the Kelo case came in and it involved a private company, Pfizer, the big drug company. Pfizer is huge, they bought about 150 people out of their homes on this piece of property in New London, Connecticut. Let's say there's 200 homes. 170 people took money for their homes and moved because Pfizer paid them money. You can always voluntarily do something. I'm talking about if you're resisting it. But there was about, let's say 20. It was less than 20. But 180, Pfizer drug company, let's say all those homes were worth $500,000. Pfizer paid every one of those 180 people $500,000 for their home and property. Then they were going to demolish it and build this huge drug facility. I think they were going to test drugs there or manufacture drugs, whatever. But 20 of those private homeowners said, no, I'm not selling. This family's been on my property since the founding of America. I'm not selling my property. Okay, what does Pfizer do? They said, well, we're going to try something new. We're going to see if we can use the eminent domain power, which is only supposed to be used for a government entity, like a city council, to take our property. Pfizer drug company came in and said, New London, we're going under your authority to demand that you use your eminent domain power to knock these people off their land. This is what the court said. It involved an economic development case. That was the argument. And it's the first time economic development has been included as a public use. Again, a public use is a church, a school, a road. That's a typical public use where government takes private property. That's typical. Here, this was for economic development. Pfizer told the City Council of New London, look, y'all city is in terrible shape. We want to buy this whole chunk of land here. 180 of the people settled out with us, but 20 won't. If we can't do it, if all 200 don't move. So we want you, for purposes of economic development, City of New London, to use your your eminent domain power to seize that property and give it to us, a private developer, take it from a private person and give it to a private party for economic development. And economic development had never been considered a quote unquote public use. So look what we're doing. And I'm going to stop after this. Pfizer is a private corporation and the people who own that land are private people. New London, Connecticut was the local government. Pfizer bought out 180 people, but 20 said, hell no. We love this land. We love our houses. We're not moving. We don't care that you want to improve economic development, Pfizer. Tough. We love this land. We're not leaving. Pfizer goes and convinces, I'm sure with some huge campaign, I shouldn't say that, campaign contributions to the, I'm joking about that. I'm sure they brought enormous pressure to bear on the city council of New London, Connecticut to say, here's Pfizer. If I'm Pfizer's lawyer, I'm going to make this argument. Pfizer, Hi, ladies and gentlemen of the council, I represent Pfizer, and we have made a motion and we are filing and asking you to use your constitutional eminent domain power as a government entity to seize the 20 homes that won't sell to us, seize it for a public use as you're allowed to do under the eminent domain power, but the public use we have in mind is for economic development. So for the first time ever, you're not taking property from a private owner to use for a public use, essentially. No, it's not even essentially. You're not taking private property of those 20 landowners to use for a hospital or a school or a road. You're taking the private property of those 20 private homeowners to use for economic development. And they're giving the land not to a government entity like a school or a hospital or something like that, but to a private developer. So that's what made people crazy. A private developer is coming in saying, you 20 people who won't sell, we're seizing. No, not seizing. We're appropriating your land. We're taking it from you. And we're using the city of New London's regular eminent domain power, which is supposed to be for a public use. We're doing it for economic development. And the eminent domain power had never been used before in a court case in that way. Economic development has not been considered a public use. Again, the way a school, hospital, road, there's lots of things that are legitimately public uses. But so that 707, that is the way the eminent domain power works. If the government takes your land, nor shall private property, which is what those homeowners had, private property be taken for public use without just compensation. Well, economic development had never been considered to be public use. And a lot of people were mad saying, Pfizer is a private corporation. You're allowing one private entity to take property from a private property owner. You can't do that under our Constitution. That was the argument. That is as far as I'm going on 5 for tonight. Next, we're going to go to the 6th Amendment. Let me see if we have any questions very quickly. 708. I hope that's clear about those powers. That's why I go over them, because I want you to see these scenarios in your mind. And again, I could drill down much further, but I don't, because it's not necessary. I want you to see these concepts. These are principles of constitutional law. Okay, let's see what we got. Mr. Alexander, has the Supreme Court broadened the Kelo case since then? And I guess what this individual in Memphis is asking is, in the Kelo case, if I understand the question, has the Supreme Court broadened the eminent domain power? I am not aware myself tonight as I sit here whether there has been another case like Kelo, but there was such a huge pushback from the federal government, from the Congress, mad at the Supreme Court saying, you cannot let a private developer like Pfizer, just because it's huge and wealthy and powerful and has 100 lawyers if it wants to, you can't let it come take these people's private property and consider economic development as qualifying as a public use. Nope. A federal highway is a public use. A local highway, a local street is a public use. A local school is a public use. There's lots of public uses, but it's the city deciding, we are the elected leadership. We have the power as it pertains to our local city government, and we're deciding to execute our eminent domain power. And it's used in those ways I just mentioned, or mentioned several times, but it had never been used for economic development. Just because New London, Connecticut was a rundown city doesn't mean those 20 homeowners and landowners deserve to have to sell their homes. Tough. Go work out something else to develop economic development here in New London. You don't get to take my house or the 20 of ours houses. Tough. You don't get to do it. So I haven't seen it go any further than that, than the New London, the Kelo case, we call it. Kelo versus New London. But it could be. It's a powerful Supreme Court precedent. If I represented a big corporation and I wanted to roll up into a city and I tried to buy a bunch of land and maybe virtually everybody sold, but 5 hard-headed people who said, oh no, we're never selling. And they were holding up the whole progress of my private development. Maybe I wanted to build ships. Maybe I wanted to buy all the landowners along the edge of the Gulf or along the edge of the bay so I can create a private corporation building ships. I need everybody on the edge of the bay to sell to me because that's where I'm going to need to set up and build the ships right on the water. So those 5 hard-headed people, they won't sell to me. I'm going to go argue to wherever that little city council is that, please, we're asking you to exercise your eminent domain power for a private developer to use for economic development. I want you to consider the taking of these people's property is for a public use, even though I'm a private corporation and you're doing it for economic development reasons. And to me, that's just not the same thing. That's not the same thing. You shouldn't have to sell your property because some corporation thinks they can come make money for themselves and the city or wherever. But still, if I were the attorney representing them, I'd go make the argument. It's a great argument. I have a Supreme Court case right on point. Why would I not make that argument? But anyway, that was the only question I see, ladies and gentlemen. Thank you for your time tonight. Thank you for your patience with me as I work through these principles. And I will see you in 2 weeks.